Hey, I'm Jennifer Moore with Marcelino Moore, and I just sat down with our estate attorney, Katie Curry. She explained her process, the varying options for estate planning, and talked about what a family of four needs in their estate plan moving forward. So take a look at this video. I hope you like it. Okay, Katie, you are our estate attorney, and I'm so excited to have you on the podcast because we haven't done this yet.
I know.
And I feel like our viewers and our clients need to understand what estate planning means and what the various options are and what your process is and all of that. So dive in.
Yeah. So estate planning can be very in-depth. A lot of times people want to come in and they're like, oh, I want to just keep things simple. And we can to an extent, but there's so much more that goes into someone's estate plan that's really important. And that's part of what I help with is guide them through this process and make them understand all the options that they have to really tailor to their needs and their goals. So we really start our process by having clients do a design meeting, an initial, consultation or design meeting, if you want to call it that. And what that does is it allows me to really get to know the client and know their goals, their needs, their family dynamic, their asset situation. Because there could be something that they tell me that they don't think could affect long-term goals and needs, but it really could. So by them telling me all of this, it allows me to really sit down and tailor that appointment to the client.
Once people give you all of that information and you now know their family dynamic, what their assets look like, what their goals are, if they have children, what are the options that can come out of that meeting for them?
Yeah. So we would talk about what would be best for their plan. Does that look like a revocable living trust? Does that look like just a will? Does it look like adding a child protection plan if they have minor children? So we would dive into all of that and really see what plan fits them best. Because someone who thinks that they just want to create a will to provide guardianship for their child. Once we start diving into, okay, well, when they turn 18, would you be comfortable with them inheriting from you if God forbid something happened to you at a young age? And most of the time clients are like, no, because I don't know about you, but if you were to inherit, or if I were to have inherited funds from my family at age 18,
they would have been long gone by now.
Exactly.
By age 40, I would have been broke.
Right. Exactly. You wouldn't have anything left.
No.
Maybe, some shoes and purses, but
yeah, a lot of stuff I didn't need.
Yeah, exactly. And so that's what a revocable living trust can do for one of the many things a revocable living trust can do for families with minor children is it allows them to delay the age of distribution for the funds. So that way, at age 18, if God forbid something had happened, they're not receiving this big lump sum of an inheritance. They can delay those inheritance to different ages, different percentages, whatever they feel comfortable with based on their family dynamic and their family plan.
Okay, so there's a will, a living will, and then there's the revocable trust. So those are the two different options in terms of documents that detail what happens after you pass away to your estate. Is that right?
Yeah. Well, not a living will.
Sorry.
No, that's okay. A living will. And that's what a lot of people will always inquire about is a living will. But a living will is actually, the formal name for it is Advanced Directive for Natural Death. It's an additional healthcare document. Why it's called living will, it's like a slang that's kind of used to refer to as living will.
I had no idea.
I don't know why it's called that, though, because it has nothing to do with your actual will. Oh. It's an additional healthcare document that speaks to life-prolonging measures, end-of-life decisions. And so it's an additional healthcare document to speak to those for your healthcare agent. Whereas the will, that's like the last will and testament that you're referring to that can tailor like your plan, either revocable living trust or will.
And so when people come to you, they have the option of the last will and testament or the revocable trust, or do you often do both together? And how does that work?
Yeah. So if you choose to go, so there's kind of like two main paths you can go down when setting up your estate plan. It's either revocable living trust plan or will-based plan. If you go the revocable living trust-based plan, you're still going to have a will, because your will encompasses a lot of other things that a trust not necessarily can't, but that a trust doesn't fully cover. So within the will, you would have guardianship for minor children, and you would also, appoint a personal representative in case anything does have to go through probate or handled on an estate administration level. But with a revocable living trust-based plan, the will is considered a pour-over will in that situation. And reason being is because, of course, the trust would encompass the whole plan and designate the distribution pattern and everything like that, and be treated as, a probate avoidance tool, which is the main purpose. A lot of people, go the trust route. But the pour-over will basically says that if anything falls outside of my trust, for whatever reason, then the primary beneficiary of my probate estate shall be my revocable living trust. That way, everything can funnel right back into the trust, and be carried out according to their trust plan.
And why is it important to avoid probate?
Probate can be lengthy, expensive, and just draining for a family. They're already going through a very emotionally taxing time and grieving, dealing with the loss of a family member. The last thing they want to deal with is the court system. And I'll tell you right now, in Mecklenburg County, even simple estates are taking a year plus to resolve.
Wow.
And that's just kind of outside of my control. It's just the court is taking a really long time to even get back on simple matters. And during that time, people are paying court fees, and they're just sitting in limbo with some of these assets, not being able to do certain things because they're waiting to get approval from the court. And so probate can just be a really big headache and costly to the family, whereas a revocable living trust can avoid that whole process for the family. By putting assets into a revocable living trust, it allows that probate process to be avoided. The trust itself isn't this big magical document that avoids probate for you, which a lot of people think. It's how the trust is handled, and that comes with how we handle your assets. So your assets get retitled, or primary beneficiary designations get updated to the trust name, and that way your assets are retitled into your trust and can kind of funnel into your trust to avoid that probate process.
So it's important to not only have an attorney like you draft the documents that are then executed, but then there's a step after that. You have to actually update your assets to funnel them into the trust.
Yes.
If you don't fund the trust, then it's just an empty document.
Exactly. And that's the other thing that I include with my packages and with my guidance for clients is I don't like them feeling lost at the end of that process. So part of our package with the trust-based plan is providing funding instructions and funding guidance, so that they're not just thrown off to the wolves and, here's your trust to figure it out.
Right.
I provide funding instructions and funding guidance to help them through that process. And that's another reason why in the very beginning we ask for asset information. So that way we can go asset by asset and guide them based on each specific asset, how it should be handled, whether it's retitle or beneficiary designation. Because exactly right. If the trust is not properly funded, it's just an empty document and it holds no weight.
Awesome. I think that those instructions, the after trust plan, that is so helpful.
Yes.
That's such great. The hand-holding still needs to happen there. I wouldn't have known what to do. I have my own trust and it is funded, but I needed that help. So that's huge.
And I think it helps give clients the additional guidance they need to feel confident in that plan down the road.
Right.
Because even though we're doing this right now and funding their trust with their current assets, this still all holds true 5, 10, 15 years down the road, right? And I'm not sitting here with them telling them about all of this, but they still need to keep that in mind as they acquire new assets and change assets and kids get older and, life happens. And so it's important for them to remember that they have this trust and know how to fund it with additional assets that come on later in life. So that way it can still be functional for years to come and not just for in the picture moment right now.
Right. Yeah. That's so important. Okay, so then if I feel like everybody should have a trust, is there a reason why somebody would just have the last will and testament and not the trust?
So, yes. I guess you have your typical lawyer answer of it depends.
Yeah, we're good at that.
Yeah. But the main reason why people avoid having a trust is money. It is more expensive to create a trust-based plan on the front end, and it's more work on the front end, right? Based on what we just talked about with asset funding and trust funding and things like that. It's more expensive to create for the attorney's fees to pay for the trust, and also more work to fund the trust. But it's more seamless for families on the back end, as opposed to a last will and testament is the absolute opposite. It's cheaper on the front end, less work on the front end, but more expensive, and more work on the back end for families. It is possible to have just a simple will, a last will and testament based plan if it was someone who maybe was living with other family members or living in assisted care, didn't have a vehicle anymore, didn't have a primary residence, didn't even have bank accounts or anything like that, or if they just had one simple checking account and they jointly owned it with a spouse or a child or, someone else. And so they really didn't have anything, and they didn't have, many survivors that they would be leaving behind, many heirs that they'd be leaving behind. And they just needed something in place just to, make their wishes known. They could have just a simple will-based plan. But typically I recommend a trust-based plan because it makes more sense for most people.
Okay. And so, in addition to the last will and testament and the trust, you mentioned some healthcare documents.
Yeah.
So what else do you do if somebody comes to you and says, yes, Katie, I want the trust-based plan, do all the things. What else is there?
Yeah. So far we've kind of been talking about the documents that come into play when you pass away. But as you mentioned, there are also documents, healthcare, power of attorney, durable general power of attorney, and those documents plan for incapacity, which are arguably just as important. Because if you don't have anything in place and something happens to you and you become incapacitated, your spouse cannot jump in and make decisions for you just because they're your spouse.
Wow. I didn't realize that.
Yeah, they don't have the legal authority to just make decisions for you just because they're your spouse under the law. So having the incapacity documents, if you will, is just as important. So the durable power of attorney, that names an agent to make business, legal, financial, basically any decision for you other than healthcare decisions if you were to become incapacitated. And then the healthcare power of attorney, that names an agent to make all healthcare, medical related decisions for you should you become incapacitated. And so for like the durable general power of attorney, it could be something as simple as, naming an agent who would be able to make utility payments for you if something happened, to make sure upkeep of your home would be okay for when you return. Or it could be something, as advanced as if you're in the middle of a divorce proceeding and something happens to you, you become incapacitated, your agent would be able to reach out and speak to your family law attorney and continue hearings on your behalf, or whatever the situation may be, until you regain capacity, if that was what your situation was looking like. And then, on the healthcare side, healthcare power of attorney, and then the living will or advance directive for natural death. Those are documents that you can execute to name an agent to make healthcare, medical related decisions, and you can provide any kind of specification or limitation that you want based on your wishes. So a lot of people in that document will put preferences on like cremation versus burial, or if they have strong religious preferences as it comes to healthcare decisions, they would put those, in the healthcare power of attorney. And then the advance directive, that allows people to indicate their wishes when it comes to life prolonging measures, end of life decisions. So those harder conversations, when it comes to, certain situations, if there was basically no coming back for you and the only way to keep you going would be to leave you on life support. And if you would not want that, in those specific situations, then you can indicate that, on this document.
Got it. And you also mentioned child guardianship.
Yes.
What does that look like?
Yeah. So on any of our packages, you can add on a child protection plan, and it allows for those with minor children to have additional peace of mind when it comes to their minor child or children. Because one of the ways to provide for guardianship in the state of North Carolina is in your will. You can provide for guardianship for your minor child in your will. But at the end of the day, that's still a court process, right? So it holds strong weight, of course. But at the end of the day, you still need the judge's stamp of approval on an order saying, yes, this person can be guardian, of my minor child. Whereas the child protection plan, it encompasses a handful of additional documents for you, to have that ease and peace of mind for planning for your minor children. So if something happened to you, would someone know who to contact to temporarily take your children? Because a lot of us in the Charlotte area, it's a big melting pot. So a lot of us are not from around here. And so I have a lot of my clients who come in and they name guardians who live, halfway across the country or live up north or, are far away and not able to be here, within an hour or two,
right.
To get their children if something happened to them. And so this child protection plan allows you to name a temporary standby guardian. It has emergency response plans, caregiver instructions. It also allows for people to provide a guardianship statement of intent. So if there is a difficult situation in the home life and mom and dad are no longer together and there's abuse involved in that or anything of that nature, you can provide a guardianship statement of intent as to why this person should never be considered for guardianship, even if they are the biological parent. Because at the end of the day, we can't take away that person's right as a parent. That's their constitutional right under the law to be a parent. And so the guardianship statement of intent can hold even greater weight in that situation to let the court know why this person should never be considered for guardian for their minor child if that's a strong concern for the client.
Interesting. Mm-hmm. Okay. There's so much nuance to that, especially as it relates to divorcing clients. And I think your advice to a family of 4 that is intact and not divorced is probably very different than it is to a client of mine, for example, who is going through divorce, who is looking to change their estate plan. Mm-hmm. And so I think we need a whole separate podcast on that.
Yeah, we definitely do. There is a lot more that we could dive into. We barely just touched the surface with all that we can do.
Yeah, so we'll dive in, but let's kind of round this out with this idea. If I am a family of 4 and I have no estate plan whatsoever, and I come to you and say, Katie, I own a house. We have 401ks. We have a brokerage account. We have checking accounts. We have cars, and my kids, are young and in school. What do I need? What would you say to me?
I would say that you would most likely need a revocable living trust with a child protection plan. That way we can protect your assets from probate if something should happen to the 2 of you. But then we can also help down the line, the inheritance to your children so that they're not receiving a lump sum at an early age. And then also provide for additional child protection for if something should happen, depending on if you're naming like faraway guardians, temporary guardians can be named and caregiver instructions provided for guardians that would step in.
And what about the healthcare power of attorney and the durable power of attorney? Is that something you would also suggest?
Yes, absolutely. I always suggest to every client that if they're doing this, it's kind of a package deal, right? Get the revocable living trust and or the will, but also we're going to do the incapacity documents because most likely if they're coming for an estate plan, they don't have those documents even in place. And so we do it all as a package deal. And so you would have, if you go the revocable living trust route, it would be the trust, the will, the power of attorney documents, the advance directive, the funding instructions, the funding guidance. All of that would be encompassed in your estate plan and part of the package deal.
Got it.